Welcome to ThePrint. For years, surrogacy remained a very viable option for couples struggling with fertility in India. However, India recently passed the Surrogacy Regulation Act 2021 to replace an earlier law that was passed in 2002, banning commercial surrogacy. Now, a lot happened between 2002 and 2021 as well. India was even at one point pegged as the surrogacy capital of the world, but both the laws more or less remain controversial. And these are the laws that we'll be discussing today in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra Sinha, and we have with us Supreme Court Advocate-on-Record Mohini Priya, who's also one of the lawyers for the petitioners in the Supreme Court who are seeking radical changes to the new law. So she is the best person to tell you about this law according to us. So thank you so much for joining us today, Mohini, and making time for us.
So, Mohini, let's before we talk or before we shed some light on this 2021 law, we would just like you to give us a brief background about how surrogacy actually, came into the picture, or how it actually was talked about, and how did the law, came into being.
See, Bhadra, surrogacy has always been a very controversial topic, especially because celebrities have been doing it, so it's media's favorite topic. Surrogacy originally started in 1978 in Kolkata, but because of the controversy surrounding it, no doctor was really too keen on doing surrogacy for a very long time. Then in 2000s, in this place in Gujarat called Anand, there were a few poor women available in slums who were ready to be surrogate mothers, and that is how surrogacy started commercially. And in 2002, surrogacy was actually legalized in India. Although there were no regulations for the same and there was no board constituted, nothing. So it remained unregulated for a very long time, which eventually led to a lot of issues. Like in the year 2005, there was this case of baby Manji, where there was a Japanese couple who had come to India to commission surrogacy through an Indian surrogate mother using eggs of a donor, which Indian donor. Obviously, it was not the mother who was using her own eggs. So that led to a lot of issues because eventually the couple got divorced while the surrogate mother was pregnant with the baby, which led to citizenship issues of the baby and, who would have custody over the baby and stuff like that. So that is where this regulation, the need for a regulation for surrogacy actually originated. Then the ICMR in 2005 came up with certain guidelines for ART clinics, ART is Assisted Reproductive Techniques clinics, which also regulated surrogacy and rights and obligations of intending couples, surrogate mothers, child. Basically, they were just regulations and they were not enforceable in courts. Then there was the case of Jan Balas in the year 2013, in which a German couple had come to commission surrogacy in India. And again, citizenship issues arose because Germany does not allow surrogacy, commercial surrogacy. So there were, these problems emanating time and again. And there was obviously a need for a regulation, and we've been waiting for that for a very long time. Then there was this PIL by Ms. Jayashree Vad, who was a social worker and a lawyer in the Bombay High Court, and she had prayed for a complete ban on commercial surrogacy. However, the government said that they are soon coming up with a regulation there, and thus the court said there is no need for a ban or even a stay on commercial surrogacy at that point. Eventually, in 2015, 15-16, the government came up with the first surrogacy and the assisted reproductive techniques bill, which could not be passed by the Lok Sabha. And, although there was the 102nd Select Committee report on that, in which there were discussions and deliberations on the viability of ban on commercial surrogacy and whether there should be an age limit for couples. And everything was discussed, and most of these things were answered in the negative. However, because that bill could never become an act, so then in 2009, the government came up with the Surrogacy Regulation Bill 2019. Again, it went through a rigorous process of discussions in both houses of the parliament. And there were many people who were still opposing the ban on commercial surrogacy there. However, in the final bill, we see that the government has actually banned commercial surrogacy. This is the history of the act. And then the Surrogacy Regulation Act came into effect on 21st January 2022.
So 2002 and 2022, So 20 years. But you said that in 2002 also there was a law, but there was no regulation.
There were no regulations.
So did that law allow commercial surrogacy?
It was being practiced. It was by way of a practice. There were no laws regarding commercial surrogacy as such. It was practiced primarily in Anand, Gujarat.
So it wasn't banned, but it was unregulated and
That's right.
practiced.
You could put it like that. Yeah.
Okay. But then, as you talked about that from 2013, when the issue arose in the courts because of certain couples, going there due to citizenship issues, until 2021 or 2022.
Yes.
So why did the government take so long for the deliberations to end? Was it such a complicated matter?
It's because, there is still a lot of stigma surrounding surrogacy. What we need to understand is that we need to have a more pragmatic approach towards this particular issue. It is not a stigma, or it is definitely unconventional, but for a small minority, it is the way of life. It is their last hope.
Okay.
So we need to understand that now with infertility affecting 1 in every 6 adult and it being classified as a disease by the WHO, this is the time when advancement in medical science and technology should come to the rescue of all these childless couples who are desperately wanting to have a biological child of their own. So instead of going into the ethical and moral issues of sale of motherhood and things like that, we should have a more rational approach towards it. We are all evolving as a society.
So
and that is how,
So was that the reason, the approaches that you spoke about, the ethical, moral
That's right,
reasons? So when commercial surrogacy was finally banned by the new law, what sort of reasons did the government give for it? What were the arguments like? Were the arguments focused on this?
Yes, the only reason given by the government was this is not socially acceptable and motherhood is not for sale. And yes, it's like, baby renting a womb, and, these terms were used. So, definitely when there are poor women and, there is a scope for exploitation, but I have to say that this present regulation has really taken good care of that. So now, as per the new act, a woman cannot be a surrogate mother more than once in her lifetime. So this old stuff called baby factory, that is gone. Okay, then there are age limits. So a surrogate mother has to be between 25 to 35 years of age. She has to be ever married and have a child of her own. And she has to do it altruistically.
Okay.
Now
that
is
that's
another
the difference.
contentious issue. Although the government has provided for 3 years insurance for the surrogate mother and also other prescribed expenses which they have not defined, in the act. So now what we have to understand that in every country where there are some other prescribed expenses other than insurance and medical expenses, that is what is a compensated surrogacy model. So what we are calling altruistic surrogacy in India is actually a compensated surrogacy model, and we have to put it forth.
Could you actually explain that for our viewers? What is allowed, and what is banned? Just
see, as per the act, the way it has been drafted, it says that commercial surrogacy, which means sale and purchase of human embryo and sale and purchase of services of motherhood, is absolutely banned, and you cannot pay a mother for her services.
So this means that you cannot pay a woman for carrying a child.
Yes, yes, specifically for that purpose.
Okay.
But when a woman agrees to be a surrogate mother, it can be altruistic, but she has to go through 9 months of pain, sacrifice. She's nurturing a baby through her umbilical cord, and you cannot really compensate her for that.
That's right.
Yeah. And even looking at it practically, which couple would be willing to, take away a baby from a surrogate mother without paying her anything? So this altruistic surrogacy model is not going to work at all. And this will just lead to underground markets because people are desperate to have a child.
So, Mohini, could you also, you right now spoke about who a surrogate mother can be. How about couples? So who can actually, what kind of couples can actually go in for surrogacy, and what should their age limit be as per the Act?
So the Act allows surrogacy for intending couples and intending women. So intending couples,
Also intending woman as well.
intending woman,
Single woman.
single woman who is either a widow or a divorcee, not an unmarried single woman as such, and she has to be between 35 to 45 years of age only. Okay. So that's an intending woman who can go in for surrogacy. As regards intending couple, the couple has to be a married couple only, Indian citizens, and the woman has to be between 23 to 50 and the man between 26 to 55 years of age. And obviously they have to have a medical indication necessitating surrogacy. So they have to get a certificate.
What are the medical indications, and from where do they get this kind of a certificate?
This certificate, they have to get it from the district board or the state board or the national board. Since in many states, the district board is not yet constituted. So these couples, yes, this is a big problem, and couples are having to approach a national board, and it's taking a lot of time.
Okay.
So this
Has it added more bureaucratic hurdles by any chance?
Of course, yeah. They have to get an certificate of essentiality from the state board or the district board or the national board. Earlier, there was also a requirement of a certificate from a magistrate, which has now been done away with. That's a good progress in this regard. But yes, the couples do have to go through bureaucratic hurdles.
And what is the definition of medical necessity? I mean, does it really...
Medical indication necessitating surrogacy is what this. So medical indication could be, maybe unhealthy eggs, or maybe the mother is born without a uterus, or there may be cases where she's suffering from some congenital heart disease or genetic disease, anything that would restrict her from becoming pregnant naturally. Yeah.
Okay. So is it that once a gynae gives an opinion, then only the couples can go to the board? Is that requirement also there?
The IVF specialist has to give her a recommendation letter, and they can take this recommendation letter to the board that we have a medical indication, and that's how the essentiality.
Now, as far as the eggs are concerned, so what does the law really say? Does it say that the eggs of the intending couple, the woman, only those eggs can be used for a surrogate baby, or the eggs of a surrogate mother can also be used?
No, see, the eggs of a surrogate mother cannot be used. That is absolutely banned under the Act. It was always banned. However, originally as the Act stood, it did allow use of donor eggs, as in the third-party eggs, for undergoing surrogacy, because there may be times where an intending couple may not have healthy eggs, or they may not have the adequate number of eggs which is required for a successful pregnancy. So that is when you need donor eggs. But recently, on 14th of March 2023, the government has come up with a new amendment saying that intending couples cannot use donor gametes now. So that has been banned now, and there is a new rule that has been inserted. It says that donor eggs cannot be used.
So whose eggs should it be then?
It has to be only of the intending couple. And when it comes to the intending woman, she can use donor sperms and her self eggs.
Okay.
Yes.
When you spoke of women who are divorced or widows, so under what circumstances can they go in for surrogacy?
Again, there's just an age bracket. She has to be between 35 to 45 years of age.
Okay, as well as the
medical condition, yes, of course.
Is also a requirement
that is a requirement.
So it has to be both the medical condition as well as the age bracket.
Yes.
Okay, now coming to the current case in the Supreme Court, which you are, contesting on behalf of the petition, on behalf of certain individuals. So, what are the questions that you have raised in the Supreme Court?
See, the petition is actually a very wide petition. So it raises questions on the scientific viability of the Act, on the exclusionary nature of the Act, because the Act does not recognize single men, single women, live-in couples, and same-sex couples at all. Although live-in couples have been given legal recognition, and homosexuality has been decriminalized, but this has not been taken into consideration at all. Apart from that, single women are allowed to adopt, but they cannot go for surrogacy.
So there is a...
Yes, that's an anomaly. And single women as widows and divorcees can go for surrogacy, but unmarried single women cannot go for surrogacy. So how does the government decide what an ideal family is and how an individual is supposed to bring up a child? So I think that is, too much government intervention in family matters, which should not have been there. Apart from that, of course, we have challenged the age limit that the government has imposed. Because frankly, these days, people get married at the age of 35 to 40. Nobody gets married at 23. So the age limit of 23 to 50 for a woman is not really reasonable enough. So that has to be relaxed, and the age should be based on a doctor's recommendation. If the woman still has healthy eggs, then why would you stop her from becoming a surrogate mother? Okay, so that is another issue that we have raised in the PIL. Apart from that, there are certain scientific issues. It says that the ART Act says that an oocyte donor, which is an egg donor for IVF, she cannot donate her eggs more than once in her lifetime. Okay. And only 7 eggs can be extracted from an oocyte donor. Now, this is a very scientific issue, so I would just like to simplify it because. So I'll first go through the numbers. So suppose 15% of the population in India suffers from infertility. Out of that, 40% would go for IVF. And only 3% of that 40% would go in for surrogacy. Okay. So IVF is a huge sector, okay? And you do allow donor eggs for IVF. But by restricting the number of times that an egg donor can donate her eggs, you are creating a huge shortage of egg donors in the country. Apart from that, there is no compensation provided for these egg donors. So they are basically supposed to donate it for free. Apart from some insurance coverage, again, 1-year insurance, there has to be a difference between insurance and compensation. They are not the same thing. So also the other aspect of extracting only 7 oocytes, that is not medically possible because there are several research papers which says that, even with the lowest dose of stimulation, you extract around 10 to 20 eggs. So how is the doctor supposed to stick to that number? So, and how is the parliament deciding what a doctor is supposed to do? So they have just invaded on a very scientific and, aspect. So this needs to be taken care of. Apart from that, yes, the huge issue is the complete ban on commercial surrogacy, which will ultimately prove to be counterproductive because altruism, frankly, is too high and ideal to be achieved, especially in a country like India, where women are the most vulnerable sections of the society. Right. And not providing any compensation for, a surrogate mother going through 9 months of pregnancy is another form of exploitation. In fact, it's a bigger form of exploitation, I would say. So it is not really serving any purpose. And compensation, I would say, is not antithesis to altruism. They should be seen together.
Yeah. So they do allow medical compensation, isn't it?
Medical expenses are allowed.
Medical expenses are allowed.
Medical expenses during pregnancy. There is 3 years insurance coverage and other prescribed expenses. So what other prescribed expenses should consist of? I'll just try to explain that surrogate mother, she has to have a child of her own as per the Act. So if she's pregnant, there has to be, somebody to take care of the child, food, accommodation, transport, and these things have not been taken care of. Just the medical expenses have been taken care of. So there has to be some amount of compensation. Government can set a limit, maybe an upper and a lower limit for that, and make it reasonable. It should not be exorbitant
and not
as to make it commercial. Yes, but they should be adequately compensated.
Now tell me one thing, in the sense, if a woman wants to become a surrogate mother, is she required to go and register herself with some board or with some authority? How do the intending couples actually look out for a surrogate mother? Does the law take care of this aspect?
See, as of now, the surrogate mother need not be a relative, but she has to be a willing woman. Now, how do you, factor in who's a willing woman and who's not a willing woman? And
willing woman who does it altruistic.
Yes. So how are you supposed to? How is even the government going to keep a check on that? So,
So this relative part was also clarified recently by the government.
Yes, there was some ambiguity in the definition of a surrogate mother. Yeah. So most doctors were under the impression, even the patients were under an impression that the surrogate mother has to be a relative. Right. But now recently the government clarified that the surrogate mother need not be a relative. She just has to be a willing woman who's ready to do it altruistically.
Okay.
But inevitably, such willing woman would either be a relative or maybe a domestic help. Who
That's
else would be willing to do it?
Yeah.
So, for your PIL, how has the government responded to it so far, or responded to the suggestions so far?
See, as far as the government is concerned, the reply that we have received is very evasive, and they haven't really answered any of our questions in a positive way, or even, really answered any of them, I would say. And the reasoning given by them has just been social inacceptability, and they have heavily relied on the 129 Select Committee report.
Okay.
Yes.
So, what did that report say?
It's a very bulky report,
Yeah.
but obviously it contained all the discussions and deliberations with expert bodies, and if we really look at the report actually supports compensated surrogacy. However, the final recommendations that have been made are, to the contrary.
Contrary,
Yeah. So the government has just relied on the final recommendations, but if you just go through the whole text of the report, you will really find that they are in support of compensation for surrogate mothers, compensation for oocyte donors, and, relaxation of age limits, and inclusion of single women, single men, live-in couples. All these things have been discussed. So it's not like a unilateral report. So now it is up to the court to look into it and decide.
One issue which you, of course, mentioned in right now was with regard to the boards. Yes. That the state boards are yet to be constituted. Yes. Is this issue also pending in the Supreme Court? Have you?
It is. We have filed an interim application saying that the state boards have not been formed, although the government claims that the state boards have been formed. But we have found out, in various states from the doctors and anyone who's dealing with it. And then they say that there are no really like formed district boards or state boards.
Okay.
So
tell me one thing, how does this really function in the sense you have a district board, state board and a national board? Yes. So is it like that if this district board denies you permission, then you appeal before the state board and then you come to the national board? Is that
there
the
is
procedure?
No provision for an appeal.
Okay, then?
No provision for an appeal. So if the district board or the state board rejects it, then you come to court directly.
You come to court directly?
Yes.
Okay, so in the absence of a district or a state board, you have to straight away come to the national board.
Yes.
And who are the members of these boards?
See, there are around 12 to 15 members of the state.
Board?
Yes, each board. And it includes people from the legal fraternity, doctors, politicians, everyone. So they're all huge boards, yeah.
Okay, with this, we've reached the end of this episode. In this episode, we told you about the Surrogacy Regulation Act 2021, how it came about, the 2002 Act, and how the new law now bans commercial surrogacy. However, whether it protects the interests of surrogate mothers and couples or not is a question that remains to be answered. Thank you so much for joining us for this episode.
Thank you.
Mohini.
It was a pleasure.
For our viewers, just to let you know again that we read all your comments. So in case if you have any suggestions for laws that you want us to take up and discuss, do let us know. And thank you so much for joining us.